5, 4, 3, 2, 1, start. In the departmental inquiry, 14 prosecution witnesses were examined. Stop. Some of these witnesses supported the case of the prosecution. Stop. Some of these witnesses supported the case of the prosecution did not. Stop. Additionally, material exhibits were also examined, such as the first information report, the memorandum of seizure of the motorcycle, and more importantly, the breath alcohol analysis test or respondent, which was positive for alcohol consumption. Stop. The delinquent constable had also examined 9 defense witnesses. Stop. All the 3 charges were ultimately proved against the respondent in the disciplinary proceedings, and he was dismissed from service. Wide order dated 18/12/1989. Stop. This order of the disciplinary authority was taken in appeal by respondent, which was also dismissed by the appellate authority on 23/8/1990. Stop. Then a review was also filed, which was also dismissed on 3/6/1994. Stop. By the time the reviewing authority had dismissed the review of the respondent, that is on 3/5/1994, the respondent, who was also facing a criminal trial, was convicted by the trial court under section 392 IPC and under section 3/25 of the Arms Act on 31/3/1994, as already referred above. Stop. Later, as we know, his conviction was set aside by the Sessions Court. Stop. Stanza. Respondent, after his acquittal, moves on application before the authorities for his reinstatement. Stop. Since the authorities did not respond favorably, he filed a writ petition in the year 1998 before a learned single judge of Rajasthan High Court. Stop. The challenge of his dismissal from service, though, was made only after his acquittal in the criminal case, yet the challenge was on various other grounds as well, such as the order of termination not being passed by the appointing authority, non-supply of inquiry report not being allowed to cross-examine the witness, etc. All these grounds did not find favor with the learned single judge, except for the ground raised by the respondent that now, since he has faced a criminal trial on the same set of charges where he was ultimately acquitted by the Sessions Court, his dismissal order is liable to be quashed and he should be reinstated in service. Stop. The learned single judge allowed this writ petition and his dismissal order was quashed, and orders for his reinstatement were made with 50% back wages. Stop. State of Rajasthan filed an appeal against this order before division bench of this court, which was dismissed on 9/9/2020. Stop. The state is now before this court against the order of reinstatement passed by the High Court. Stop. Stanza. We must reiterate the High Court, both in the writ petition and special appeal, had allowed the case of respondent Phul Singh only on the ground that now, since he has been acquitted by a criminal court on the same set of facts and charges on which he had faced a departmental proceeding, the orders passed in departmental proceedings are liable to be quashed and he must be reinstated in service. Stop. As we have already referred above, none of the other arguments raised on behalf of the private respondent challenging procedural anomalies in the departmental proceedings, violation of principles of natural justice and fair play, or lack of jurisdiction of the authority had found favor with either the learned single judge or the division bench. The case of the state, who is the appellant before this court, is that the respondent was a member of a disciplined force. There were extremely serious charges against the respondent in the departmental proceedings. He was charged of threatening and extorting money from a member of public, roaming in a public place under influence of liquor, and then using a firearm and causing injuries, which were all very serious charges. Respondent was given fully opportunity to defend his case in the departmental proceedings. He was given the opportunity to cross-examine the prosecution witnesses, and in fact he also presented 9 defense witnesses who were examined in the departmental proceedings. The disciplinary authority concluded that the delinquent constable (respondent) had committed an act of gross indiscipline and negligence, as well as dereliction of duties and of misbehavior and misconduct, and all this had tarnished the image of Rajasthan police in public. Under the circumstances, the delinquent officer cannot be retained in police service and was thus dismissed from service with immediate effect. The state would also argue that the acquittal by the criminal court is of no consequence as far as departmental proceedings are concerned. The question before this court is therefore only to see whether the respondent can be reinstated in service, for the reason that now on the same set of charges he has been acquitted by a criminal court. There should be no ambiguity in law on this subject. Stanza. A departmental proceeding is different from a criminal proceeding. The fundamental difference between the two is that whereas in a departmental proceeding a delinquent employee can be held guilty on the basis of preponderance of probabilities, in a criminal court the prosecution has to prove its case beyond reasonable doubt. In short, the difference between the two proceedings would lie in the nature of the evidence and the degree of its scrutiny. The two forums therefore run at different levels. For this reason, this court has consistently held that merely because a person has been acquitted in a criminal trial, he cannot be ipso facto reinstated in service. Over.